All right, let's just set the scene. You have to go back with us to Thursday morning.
Just a few days ago, yeah.
Yeah, exactly. 10:03 a.m. Eastern Time.
Mm.
And, when the Supreme Court drops a big decision, there's a whole fanfare.
Oh, it's a circus. It's
Ah,
absolute
There
chaos.
you had cameras, reporters running around. But this was different.
This was silence.
Total silence.
Mm.
No press conference, nothing. Just a notification that popped up on a server. 2 words.
Application denied.
And like that, what was probably the biggest legal firewall around a former president and a current cabinet nominee, it just, poof, it was gone.
It didn't just crack, it completely evaporated. And frankly, the silence from the court on this, it was louder than any 60-page opinion they could have possibly written.
We are talking, of course, about the ruling that completely clears the way for Melania Trump to testify before a grand jury against her former husband. So today, we're not just going to look at the headline. We're going to deconstruct this insane 72-hour legal whirlwind that led to this moment.
Right.
We're going to crack open this Proffer agreement. And if you don't know what that term means, you need to stick around because it is the absolute key to this entire thing.
It's the prosecution's roadmap. It lays out everything.
And we're also going to debunk a legal myth that I swear like 90% of people think is real. Spousal privilege.
Oh, yeah. The TV version is, let's just say it's the opposite of reality.
It's totally wrong. Okay, so let's start with the timeline.
Yeah.
Because the speed of this is what makes it so devastating for the defense.
It was a chain reaction, an absolute sprint. And it all kicked off on Monday, around 2:00 p.m.
Okay, what happened?
That's when Melania's legal team submitted the Proffer agreement to the prosecutors.
All right, stop there. Proffer. It sounds so formal. Break that down. What is it in plain English?
Think of it like a free sample, or maybe a movie trailer.
Okay.
In the federal system, you can't just walk in and demand immunity. You have to prove you have something worth their time.
You have to show them the goods first.
Exactly. A proffer is basically the witness saying, look, if you give me protection, here's exactly what I can tell you. Here are the documents I have. Here's what I heard. It's a preview.
So you're showing your hand. That feels risky.
It's a huge risk. But there's usually an agreement that if the prosecutors walk away, they can't use your specific statements from that meeting against you. But the fact that her team submitted it, that tells you one thing.
She wants to make a deal.
She's initiating. She's not being dragged into this kicking and screaming. She's volunteering. And that just changes the whole game.
Which explains the absolute panic that came next. So Monday, the proffer lands. Then Tuesday afternoon, less than 24 hours later.
An emergency appeal to the Supreme Court.
I mean, I'm not a lawyer, but that seems incredibly fast for the Supreme Court.
It's lightning speed. Drafting one of those appeals is. It's a mountain of work. It's incredibly technical. To do that in 24 hours means one thing.
They already had it written.
They had it sitting in a drawer, ready to go. They knew she was going to cooperate. They were just waiting for her to pull the trigger.
Wow. And what was their argument in this emergency filing?
They were asking for a stay, to freeze everything. They argued that her testifying would violate marital privacy under the Fifth Amendment. I mean, they were trying to create a constitutional crisis just to stop the clock.
Which brings us to Wednesday, the day of silence.
Right. The court puts the appeal on the docket, so it's officially there. But they don't issue a stay.
And a stay is basically the pause button.
It's the pause button. And for the court watchers out there, you know this is a huge tell. If even one or two of the justices thought, maybe there's something to this, they would have issued a temporary stay, just to read the briefs.
Just to buy some time to think it over.
Exactly. But Wednesday came and went, nothing. The clock just kept on ticking. I imagine the defense team was sweating bullets.
And that leads us right back to where we started. Thursday morning, 10:03 a.m., application denied. But here's the detail that just floored me. 0 dissents.
That's the kill shot.
Explain why that's so significant. I mean, this is supposed to be a deeply divided court, right?
Yeah.
Gorsuch, Kavanaugh, Barrett, all appointed by the defendant.
And Thomas and Alito.
And not one of them wrote a single word saying, hey, maybe we should look at this.
Not one. Usually, even in a denial like this, if a justice thinks there's a real legal question, they'll write a dissent. It's a signal, that the issue isn't settled. It gives the losing side something to hang their hat on.
But here, it was just a flat no.
A unanimous rejection. It's the court basically saying, this argument is so baseless, we're not even going to discuss it.
It's legally frivolous.
Exactly. It's like a teacher not just failing your paper, but handing it back ungraded because the whole premise is wrong. The firewall is gone.
So with that legal barrier just completely demolished, now we get to the real substance. What's in the proffer?
This is where it gets really ugly for the defense.
According to the sources, it's broken down into 3 specific categories of evidence. Let's start with the first one, financial records.
The paper trail.
We're talking joint tax returns from 2014 all the way through 2020.
6 full years.
So why is it so important that they're joint returns? I mean, lots of people file jointly.
Well, when you sign a joint return, you're both signing under penalty of perjury. You're both swearing that it's true. No, a lot of the time, a spouse can claim, the innocent spouse defense.
Right. I didn't read it. I just signed where he pointed.
Exactly. I had no idea. But what the proffer alleges is that she can't use that defense. She wasn't just signing. She was in the meetings. She knew the strategy.
And the strategy was this classic 2 sets of books, fraud, right?
It's the oldest trick in the real estate playbook, just on a massive scale. It's all about valuation.
So you go to the bank for a loan.
And you say your building is worth $100 million because you want a huge loan on great terms.
But then when the tax assessor calls,
suddenly, oh, the market's terrible. This building is barely worth $10 million, so you pay less in property taxes.
you're telling the bank it's worth $100 million and the IRS it's worth 10 for the same building at the same time.
That $90 million gap, that's fraud. And the proffer says she can testify that it wasn't a mistake, it was the plan.
Which brings us to category 2, communications. Because you have to prove they meant to do it. You have to prove intent.
Intent is everything. It's the hardest thing to prove. The usual defense is, oh, I relied on my accountants, I'm not a numbers person.
They must have messed up.
Right. But the proffer apparently includes texts and emails between Melania and the defendant, discussing the property values before they went to the lenders.
So they're getting their story straight.
It looks like it. But then there's the real bombshell. The source says the proffer includes recordings.
Okay, that's just wild. Who records their own spouse talking about loan applications?
Someone who wants an insurance policy. Yeah. In the world of high-stakes business and, well, certain kinds of marriages, people protect themselves.
But are those even admissible in court? I thought you couldn't secretly record people.
You can if you are part of the conversation. In New York, it's a one-party consent state. As long as she knew she was recording, it's legal.
Wow.
But here's the critical part. Federal prosecutors are beyond cautious about this stuff. If they've accepted these recordings into the proffer, it means they've already had them analyzed.
Make sure they're real, not deep fakes, not edited.
Exactly. They believe the tapes are authentic, and they believe they fall under something called the crime fraud exception.
Okay, what's that?
It's a legal wrecking ball. Normally, conversations between spouses are privileged, but if you're using those conversations to plan a crime together, like bank fraud,
the privilege just disappears.
It's gone. The marriage can't be used as a shield for a criminal conspiracy. It's just two co-conspirators on tape.
This is incredible. And hey, before we move on, if this deep dive is making your jaw drop too, do us a quick favor. Hit that subscribe button, maybe leave a comment with your take on this, and click the bell. This story's moving so fast, you really do not want to miss the next update.
You really don't.
Okay, so that tape leads to the third category of evidence, right?
Right. Corroboration.
What does that mean here?
You have to remember, the grand jury has already heard from other people. They've heard from the accountants, the bankers, the appraisers.
And all those people are trying to save their own skin, presumably.
Of course. So you have a situation where the accountant says, they told me to use the fake numbers, and the defendant says, no, the accountant did it on his own. It's a he said, she said.
A standoff.
But now, Melania walks in, and if she says, actually, I was on the phone call, the accountant is telling the truth, we told him to do it.
It tips the entire scale. It's not he said, she said anymore. It's
everyone said. It makes the case almost impossible to defend.
Okay, let's circle back to this spousal privilege idea, because I'm still stuck on it.
Yeah.
I mean, my entire understanding from pop culture is that he can just stop her.
I know. It is one of the most powerful and persistent legal myths in America.
So it's just wrong.
It's completely wrong. It used to be true, like 100 years ago, under old common law, where a wife was basically her husband's property. But the law has evolved a lot.
So what's the actual rule now?
The big case is called Trammell v. United States. It's from 1980, and the Supreme Court was crystal clear. The privilege belongs to the witness, not the defendant.
So the person testifying holds all the cards.
All of them. The court said a defendant cannot be allowed to silence a spouse who wants to come forward and tell the truth. If she wants to waive her privilege and testify, He has zero power to stop her.
He can't legally gag her.
He can't. And his lawyers knew this, which is why their appeal was such a Hail Mary. They tried to argue this case was special about marital privacy. They were hoping the conservative justices would, buy into this idea of protecting the institution of marriage.
But they didn't bite.
Not even a little. By rejecting it unanimously, they basically slammed the door on that argument for good, and they reinforced a key point. Her lawyer submitted a sworn statement that she initiated this. She wasn't dragged in. She knocked on their door. That makes it voluntary cooperation, which makes the privilege argument completely dead on arrival.
Okay, so the barrier's gone. The evidence is on the table. What happens now? What's the timeline?
It's going to move very, very fast. The grand jury for this district meets on Tuesdays and Thursdays. The denial came on a Thursday, so she could literally be testifying this coming Tuesday.
That quickly.
Oh, yeah. They have the proffer. They know what she'll say. They just need to get her in there, swear her in, and get it on the official record.
And once her testimony is locked in, what do the prosecutors do?
They have two main paths. Path one is simple. Use her testimony to make the existing charges, the bank fraud, the falsifying records, absolutely ironclad.
And path two, the aggressive option.
A superseding indictment.
That sounds serious. What is it?
It means they rip up the old indictment and file a brand new one with more and more serious charges.
And the evidence points toward that.
The source mentions something specific, a phone call from March of 2020.
Right as the world was shutting down.
In the middle of all that chaos, there's a conference call. The defendant, a banker, and Melania, all talking about property values.
And if they all agreed to use the fake numbers on that call.
That is the literal definition of conspiracy to commit bank fraud.
Which is a whole different crime.
It's a separate, very serious felony. And adding a conspiracy charge gives the prosecution a lot more leverage.
And we have this huge collision course coming up on the calendar. There's a cabinet confirmation hearing in early March. The trial itself is set for September 16th.
Right. And until last Thursday, the defense strategy was obviously delay, kick the trial past the confirmation, maybe past the election.
But the Supreme Court just blew that strategy to bits.
They took away their biggest weapon, time. Now that September trial date looks very, very real. But the immediate problem for him is the confirmation hearing.
I can't even imagine. You're sitting there in front of a Senate committee while the news ticker at the bottom of the screen says your ex-wife is testifying against you in a bank fraud case.
It's a political nightmare. It turns a confirmation hearing into a public trial on his character.
It's an absolute mess.
Yeah.
Let's zoom out for a second. What are the bigger takeaways here, beyond just this one case?
I think there are three. First, this really solidifies that spousal cooperation is protected. It sends a message that, family secrets don't shield you from financial crimes.
So you can't use your marriage as a get-out-of-jail-free card.
Not if your spouse decides to save themselves. Second, the Supreme Court's action here was a clear shot across the bow against using the legal system for delay tactics. They basically said, don't waste our time with frivolous appeals.
Honestly, that's kind of reassuring.
And that's the third point, accountability. For all the talk about a two-tiered system of justice, look at what happened here. The system actually worked. The courts moved fast. No special treatment because he's a former president or a nominee.
The gears just turn the way they're supposed to.
They did. And that matters. If you're out there listening, maybe you're retired, you've spent your whole life paying your taxes on time. It's infuriating to see powerful people act like the rules don't apply.
It eats away at your trust in the whole system.
Exactly. And this ruling, these two words, application denied, they're a small reminder that evidence still matters. You can't spin a signed tax return.
And you definitely can't spin a unanimous Supreme Court. So let's just recap. The court's silence was deafening. The barrier is down. The testimony is coming.
And the defense has run out of road. No more appeals, no more delays. It's just the facts now.
It's just a final thought. We always focus on the loudest parts of politics, the rallies, the shouting. But here, the biggest blow wasn't to speech. It was a quiet signature on a proffer agreement.
Which really raises a question, doesn't it? In a world of noise and bluster, what happens when the one person who knows where all the bodies are buried just decides to hand over the shovel?
Something to think about. Thanks for taking this deep dive with us. And one last time, if you want to follow this to the end, make sure you subscribe with that notification bell on. When that testimony drops, we'll be right back here to break it all down.
Stay informed.
And stay curious. We'll catch you on the next one.